and the lesser included offenses if you get that far, and also beyond a reasonable doubt to disproving the justification in this case. And I'll talk about that in just a minute. That's in the charge that the court just gave you. 2 seconds to comply, 2 minutes to die. Those were words that I used in my opening statements, and now you probably have some frame of reference for them after seeing the videos in this case. We'll talk a little bit more about that in just a minute. The charged offense here that the judge has told you about is manslaughter. A person commits an offense if he, and it's basically got 4 elements, recklessly causes the death of an individual. Pretty simple, right? So let's talk about the easiest one, an individual, the person we've been talking about throughout this case, Javier Ambler. That's what the charge says. We've also referred to him as Javier Ambler Jr. or as Javier or Mr. Ambler. This is who we're talking about here. This photo was shown to you earlier in the trial, and this is Mr. Ambler with his children. And then another element of those 4 is death. This is another one that isn't that complicated in this case. You've seen videos depicting what happened here at the scene. You've also seen a video, you may remember, from Deputy Rachel Carter, now known as Rachel Lentz. Very early on in the trial, one of the first witnesses, she had her body cam on. She arrived at the scene. She caught some of the action at the scene. She sees the tasers, as you may recall. She marked some cartridges at the scene from the tasing. She also went to the hospital. Do you remember that? She went to the hospital, and her body camera captured the things that happened at the hospital. She was supposed to capture the probes, remember, pictures of them before they were taken out of Javier's body. But she couldn't do that because the doctors were trying to save his life. Remember that? And then she ended up collecting a couple of probes and a cartridge, some wires from the scene, and her body camera caught a video of the doctor declaring death, as I recall. So you have that in your evidence before you. We also have the medical examiner's report, autopsy photos. I apologize, those can be very disturbing. Del Seaton medical records reflecting what happened there that night on March 28th of 2019. So one of the things that we have in this case that we talked about also in jury selection is we have manner and means stated in the indictment. So we have more than one way that the actions we're talking about could have occurred. In this case, we have more than one way in which the forcible restraint acts or manner and means are alleged to have occurred in this case. And we talked about this at jury selection, but you have to be unanimous about causing the death and recklessly and an individual. But you don't have to be unanimous about whether it was any one of these enumerated manner and means, what we call manner and means. So I'm going to go through them now. So the indictment states, did then and there recklessly cause the death of an individual, Javier Ambler, by striking with a conducted electrical device. We're talking about tasing. There's been a lot of talk about tasing in this case, that you've seen evidence of it. By seizing the back of Javier Ambler with the defendant's hand. By seizing the hand of Javier Ambler with the defendant's hand. By seizing the arm of Javier Ambler with the defendant's hand. By seizing the head of Javier Ambler with the defendant's hand. By pinning the back of Javier Ambler with the defendant's knee. By striking Javier Ambler with the defendant's knee. And by restraining Javier Ambler with the defendant's handcuffs. Those are the different manner and means that are provided for that you will find in the charge as well. And what we're saying is, in this case, what you have to be unanimous about is that these defendants, each of these defendants, caused the death of Javier Ambler with regard to one of these manner and means. You don't have to agree on which one it is. You could agree on all of them. You could only agree on one of them. You just have to be unanimous about whether or not the defendant caused the death of Javier Ambler through one or more of these manner and means. So let's talk a little bit about some of the video evidence that you've seen to substantiate some of these manner and means. I have a few video clips that are contained within this presentation, which are all taken from videos that you have in evidence that you could watch. Our first deployment of a taser in this series of events.
We need to object and have the jury be instructed that's not to be considered.
Okay. Can you approach, please? To be clear, that initial taser strike alone is not to be considered in isolation as a manner and means. Okay, that should not be your manner and means specifically that you agree on in this case. I am showing that as part of the criminal transaction that occurred in this case and the first tasing that occurred, so that you have context for the rest of the interaction. So that is an example of another taser deployment in this case. You remember the kind of a rattly sound that we talked about earlier in the trial? This particular excerpt contains that sound, and witnesses told us that that is indicative of a taser being employed. And you hear that multiple times in this interaction. I apologize, we're going to try to get the volume moderated a little bit here. And here is another example of some of the conduct that we're talking about with regard to manner and means. So this one is an example of use of a foot, a knee strike, and another tase. And of course, these videos are available for you in evidence. And this is a new video. We actually didn't display this for you in the courtroom, but it's been admitted in evidence as State's Exhibit 127, so you have it if you want to watch it. Officer Chung arrived kind of late in what was going on, but his body camera did capture some of the events on the ground. So those are some examples of things that you can look for when you go through the videos. There's some other evidence that you can view, of course, the medical examiner's report, photographs, testimony of witnesses as well, to decide whether or not you are in agreement on one or more of those manner and means. I want to talk a little bit about what we call, as lawyers speak, is law of parties. And it's also known as criminal responsibility for the conduct of another. And the law provides that acting with intent to promote or assist if a party solicits, encourages, directs, aids, or attempts to aid another person to commit an offense, then that person is criminally responsible for the other person's conduct. What this means is, and you may recall during jury selection, I had a slide with Bonnie and Clyde on it. This is basically, the point is, if two people are acting together and they have the necessary intent and they're encouraging and aiding each other, then they're parties to the offense. And each of them is responsible for the actions of the other. So I want to tell you that because when you're evaluating manner and means, you can, if you find that people are criminally responsible for each other's actions, you can find one of them is responsible for the other person's actions, and vice versa. So, one of the other things that you have available to you in this case, and I will tell you where these can be found in the information that you have. You have the dash cam recording of Deputy Johnson. You also have a body cam recording from a witness whose name is James David. He was a lieutenant at the time of these events, and he is now a chief over at Williamson County Sheriff's Office. He testified last week. You have his body camera in evidence. We didn't watch a whole lot of it. On his body camera, he talks to both of these defendants about what happened that day, and they make statements to him. Likewise, on Deputy Johnson's dash cam, after the incident that occurred, a little bit later in that video, you will find that there are some statements by Deputy Johnson that he makes that are audible. You can't see him on the video, but you can hear him. He talks about what happened. We'll talk about a few of those statements now. So some of the things that Deputy Johnson said about what happened, he jumped out of the car talking about Javier. I told him to get on the ground, get on the ground. I transitioned to less lethal. He wouldn't get on the ground. I lit him up. He fell. He stated he got out and he started kind of walking towards the back, and I'm giving him commands. This is something we've already talked about. Feel free to examine the exhibits and compare them against these statements. I would suggest to you that at no point did Javier walk towards the back of the car. He never had an opportunity to. We got one hand cuffed. He kept pulling it. He got tased again. I lit him again. You've heard some conversation and dispute about how many times Javier was tased during these incidents. I can tell you right now, Deputy Johnson's own statements indicate that he tased more than once. He also stated that the APD deputy, we're talking about Officer Nissen, probably right, is working on one hand, me and Camden are working on the other. So these are some of the statements that he made to describe his conduct. Let's talk about some of the statements that Deputy Camden made. I ran in, planted my knee to the back of his neck. I pulled my taser in his back to have another contact, let him work. Johnson had already deployed his taser and he was down on the ground. This was a question, he answered yes. I was on his neck. I was trying to get his right hand. He kept trying to pull it. Again, I deployed my taser. I think it was the back of his neck, might have been his back. So once again, you're hearing from Deputy Camden himself concerning his actions, tasing, putting his knee in, and his conduct. Also on that last one, he clarified that he had the cartridge on when he deployed his taser that time. One question that may be relevant to your analysis, and there's been a lot of discussion about whether or not these deputies were concerned about whether or not Javier had a weapon. I suggest to you that the evidence in this case is going to show you that at no time did Javier have a weapon. There was no weapon in the car, and these defendants, at least from the point that he emerged from the car, did not have any reason or concern, express any concern that he had a weapon. It's not evident at any point in the statements they made about what they did that they were worried about a weapon. At the point after these events occurred, Officer Nissen observed that Javier appeared scared, panicked, not combative and aggressive. Nissen observed that Javier was trying to prop himself up. Nissen never observed him with a weapon and never reached for a weapon. You may recall that Nissen is also the officer who cleared the car. No one called out weapon. You don't hear it on the video, and I believe it was Officer Nissen that said that no one called out that he had a weapon. No weapons were found by Officer Nissen when he cleared the vehicle. No weapons were found in the vehicle inventory. You may recall that Detective Trujo conducted that inventory. No weapons were found. Let's talk a little bit about Colin Micah. Do you remember he was the Life PD crew member that was riding in Deputy Johnson's car, right? He came in to testify, and he said some different things on direct examination, kind of than he did on cross-examination, so he's one of those witnesses that you'll need to kind of assess his credibility. I would say that my recollection is that he said that if he had been, and this was probably on redirect, after he was subjected to cross-examination, when I was questioning him again, he said that if he had been in fear, he would have run behind Deputy Johnson's car, and he did not. As you may recall, he ran right up to Ambler's car, running right behind Johnson the whole time with the camera, getting the best view with a bright light. And you can see this in the videos. He said, however, that he did not remember seeing a weapon at all. He said that he remembered that Johnson did holster his firearm. As you recall, when Johnson ran up to the car, he initially has his firearm out, he holsters it and pulls the taser, and then tases almost immediately. And Colin said he holstered his firearm, which indicates he does not believe there's a deadly threat right in front of him. Colin also conceded that Javier rolled over when asked. You may recall initially he said he was resisting the whole time, and I pressed him on that. We looked at the video a little bit, and I said, look, was he asked to roll over? Did he roll over? He said yes. I asked, was he asked to bring his arms behind him? Did he raise his left arm? Yes, but a deputy pushed it back down, and then we talked about the right arm being raised by Ambler. So he also agreed that initially he was given 2 or very few seconds to comply with Deputy Johnson's commands. And this would have been very difficult, I believe, that you can use your common sense to decide based on Javier's size, which was self-evident to the deputies when they arrived. Let's talk a little bit about causation. It's a big deal in this case. We talked about it at jury selection. The law is a little bit confusing, but it's one that we have to ask you to interpret. So the law provides that an actor is criminally responsible if the result, in this case, the death of Javier, would not have occurred but for his conduct. We're talking about a defendant now. Operating either alone or concurrently with another cause. In this case, one of those might be the pre-existing medical conditions like congestive heart failure that we've talked about. Unless the concurrent cause was clearly sufficient to produce the result and the actor's conduct clearly insufficient. So that's some of the language that we've talked about. We'll be asking you to try to interpret it in this case. As a shorthand, we talk about but-for cause. Were the actions of these defendants the but-for cause of the death in this case? That's what we're thinking about when we talk about that causation element. So some of the evidence we would ask you to look at in making this decision would include the medical examiner's report. Remember Dr. Keith Pinkard, I think he testified on Monday. He's our chief medical examiner here in Travis County. He worked with another medical examiner named Dr. Lemieux. And they did this autopsy report. They viewed a lot of evidence. They looked at videos. They examined the body. And they stated that the cause of death in this case was congestive heart failure and hypertensive cardiovascular disease associated with morbid obesity in combination with forcible restraint. In combination with forcible restraint. So we have multiple factors operating here. How do we know whether the forcible restraint is the but-for cause? This is an important component. He designated the manner of death as homicide. Now, he did say that is a non-legal classification. It doesn't assess intent. Homicide is an administrative classification used by medical examiners. It doesn't assess the intent of the actor, and it doesn't mean that we have someone criminally liable just because somebody put homicide on a medical examiner's report. That's true. However, the testimony of Dr. Pinkard and also the testimony of Dr. Michael Freeman. Remember Michael Freeman from last week on Friday? He's the forensic epidemiologist, Fulbright fellow, really accomplished guy. They both testified about what homicide means in this context, and it means that the death has resulted at the hands of another person. And it also means that that person committed one or more volitional or harmful acts and that they were directed at the victim. So that is an essential component of the medical examiner's report, which you have in evidence and you can refer to, and I suggest to you it's an important consideration to you in deciding about causation in this case, which is an important issue that you have to determine. I would also direct you to some of Dr. Pinkard's testimony. He basically said there was no way to separate the forcible restraint from Javier's death. Javier did not die at home from his diseases, he pointed out. He didn't die at home from his diseases. He died at this moment after being subjected to forcible restraint, including multiple tasings. He said that the struggle with these officers would have exacerbated his heart's underlying condition, and that electrical injury, in other words, tasing, can affect the heart and it can induce a fatal arrhythmia. He also stated, when asked about Javier initially emerging from the car, that if he was walking and talking, he was not experiencing sudden cardiac arrest. So you can look at the videos and you can decide for yourself whether that was the case. Other evidence of causation that you might want to consider, the testimony of Javier's sister, Ms. Moore, and also Ms. Betia. They talked about Javier's pre-existing conditions, hypertension, congestive heart failure. He had some issue with his legs, if you might remember, some swelling and some lesions on his legs. These were associated with his congestive heart failure. But they said he was dealing with these things. He had prescriptions. He was still actively engaged in life with his family and doing active things with his kids. In fact, he even took care of his 3-year-old, Joel, 2 days before March 28th of 2019. Michelle told you that. So the man was, he was vigorous enough at that point and healthy enough at that point to care for a 3-year-old, and anyone who's ever cared for a 3-year-old knows that's no small feat. Jacob Palmer, he was the EMT in this case that testified. He said the evidence at the scene showed cardiac arrest, and it was not likely caused by the car wreck. A couple of witnesses talked about the fact that the front airbags didn't deploy in the car wreck, and if you look at the pictures from the inventory, you'll see that the front hood of the car wasn't crushed in. So they decided that the cardiac arrest was likely caused by something that happened after that final impact. Also, we talked about Deputy Carter and what she collected from the hospital. Briefly, I want to go back to Dr. Michael Freeman because I think his testimony is super important, especially when you're thinking about deciding the issue of causation. Dr. Freeman talked about the pre-existing conditions, and he said all those, the hypertensive heart disease and the hypertension and those other disease processes that were going on were there for years before this restraint. And it's important to also look at the timing, the temporal relationship. He talked a lot about timing because restraint was the thing that happened 2 minutes before the death, okay? Restraint was the thing that happened 2 minutes before the death. He also specifically, he said as a forensic epidemiologist, causation is one of the things that he studies. And he talked about the fact that this but-for causation, he said if you're talking about the but-for standard, this man is not dying when he gets out of the car, and then he's dead a few minutes later after having force used on him in a variety of ways. So he's addressing the forcible restraint and saying it is the but-for cause of Javier's death. Additionally, when I asked him what did cause Javier Jr.'s death on March 28, 2019, he said the actions taken by the officers from the first taser until the time that he became unresponsive, including the additional taser shocks, the restraint, and the preventing him from actually being able to hold himself up so that he was not compressing his abdomen to his diaphragm. Remember, he talked a lot about how Mr. Ambler would, with his pre-existing conditions, if forced flat on the ground, would have not been literally not been able to breathe. He was struggling to breathe, and when he said, "I can't breathe," he wasn't kidding. He could not breathe. Tasing and in-custody deaths. This was an interesting factor. Dr. Freeman has actually studied over 150 in-custody deaths in detail. That's part of his expertise. He said that over half, maybe 60%, did involve tasing in some way. And I'm not suggesting causation here for those who have a scientific background. He said that these were associated. These in-custody deaths did involve some kind of tasing. You may recall, and this is something that the defense has talked about a whole lot, NMI. Remember stiffening up, that you've got to have a stiffening up if the taser's going to fully take effect. So I asked Dr. Freeman, I said, how many of those deaths, those in-custody deaths that involve some kind of tasing, did you see in your study of them had this stiffening up, this NMI? Do you remember what he said? That would be rare. No, I did not see much of it at all. That would be rare. So, next element in manslaughter is the concept of recklessly. The defendant's actions, you would have to find beyond a reasonable doubt that they acted recklessly. And what that means, a person is reckless with respect to the result of his conduct, in this case, Javier's death, if he is aware of but consciously disregards a substantial and unjustifiable risk that the result, in this case death, will occur. So the law provides that that risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. So from the indictment, the allegation is that the defendants acted recklessly, namely by continuing all described restraint and actions when Javier Ambler stated on multiple occasions he could not breathe and had a health condition. So what evidence do we have that he stated he could not breathe, that he had a health condition? In this case, he expressly stated that he had congestive heart failure. We have a few video excerpts that I'm going to try to play if they don't blast everyone's ears.
I need you to comply.
bit about some of the witnesses' statements that you can look at in making this decision. You remember Ruby Tarzian? She's one of the live PD crew members. She was riding in Deputy Camden's car. She stated that she heard Javier say he had congestive heart failure, and she heard it multiple times, and she heard it from sitting in the car with the car window rolled down. And that's not the car even that was closest to this encounter. She was in Camden's car, not Johnson's car, which was closer. So she heard it from the car. Jeff Moriarty said that he had COPD. Maybe we have a memory issue there, or maybe at some point he said he had COPD. I didn't hear that. Let's talk a little bit about the whiteboard, because we mentioned the live PD crew members. I want to suggest that if you want to take a look at this, it states Exhibit 100 in your materials. This is the place where the two departments, Williamson County Sheriff's Office and Austin Police Department's SIU, divided up the tasks that each of these agencies would do. And I told you when we started this trial that we may have some questions at the end of it. Certainly not all the evidence that you wanted to see may be in front of you right now. I ask that you consider the exceptional circumstances that occurred in this case and the evidence that this whiteboard provides in terms of divvying up tasks, and also consider, please, the testimony of Detective Trujo and all of her attempts to get the relevant evidence. I believe that also you do have, despite some of the evidence that you don't have, you do have sufficient evidence to reach a verdict beyond a reasonable doubt in this case. I would suggest that critical evidence that you do have includes Deputy Johnson's dash cam, Officer Nissen's body-worn camera, Officer Chung's body-worn camera, all of the witness testimony that you heard from the witness stand. I want to direct your attention also to those taser logs. You remember the taser logs? We talked about the tasers, the serial number. We had a couple of witnesses last week that matched up the serial numbers with those taser logs. Those show the deployments of the tasers on that day. 2 deployments for each of the tasers. Take that into account when you review the witness testimony, when you review the other evidence in front of you, including the videos. Think about those taser logs. Also, we have the medical examiner's report. It details a lot of injuries in addition to the conclusions about the cause of death and manner of death. If you have any concerns about the toxicology, that's where you can find it. I would suggest to you that multiple witnesses testified that that was not the but-for cause of his death or had any role in it. And finally, the expert testimony. I think you have some great experts that testified for you to take into account in your analysis. We sure hope that you will look at the testimony of Mr. Roger Clark, a 27-year veteran of the Los Angeles County Sheriff's Office, the testimony of Dr. Michael Freeman, internationally recognized forensic epidemiologist, and Dr. Pinkard, our medical examiner. I want to remind you also of some testimony from Detective Trujo, the lead detective in this case, and she documented that Javier Ambler stated several times, "I can't breathe, I'm not resisting," and also that he stated he was dying. And we also have the statements of Deputy Johnson, who did say that he had heard Javier saying, "I can't breathe." He said he was fighting us, but he acknowledged hearing it. And then at another point, he said he was talking to me like, "I can't, I'm not going to, I can't breathe," or something like that. I would suggest to you, if you evaluate Javier's statements on the videos, I think you may not find all of that, but you will find the part about "I can't breathe" probably 6-7 times. Taser training. I think this is relevant to your analysis that both of these defendants had been trained in taser use. You have the TCOL training records in evidence here. So if you're curious about when they received that training, take a look at those records. Both of them, I would suggest to you, received training within the previous year before this incident occurred. If you need the code, it's 3347 or 3344. And this is in the tasing records, or the training records of TCOL that you can look in. You also heard the testimony of the defense called Anthony Ramirez. He is the trainer at Bastrop County Sheriff's Office, and I believe he stated that he had trained these defendants, at least Deputy Camden. He also interestingly mentioned that after 20 years of working a lot of it patrol on the street, he had never once, as a taser trainer, used his own taser on the street. Yet these defendants used theirs 3 or 4 times in this incident. Other law enforcement testimony you might want to look at, Sergeant Gilbert from APD, he was one of the officers. He had worked on downloading the information from the tasers. He said, "It is not my position to delay medical care." When discussing how he would handle a subject who was in medical distress. Officer Nissen also said that he was trained to treat people who are morbidly obese carefully. And I will note also that Officer Nissen, the evidence showed, never unholstered his taser during this interaction. The defense called these 2 witnesses. Some of the issues that they talked about, subjects with pre-existing injuries, medical conditions, should not be tased. Do you remember when we had the tasing demonstration? We discussed the fact that Mr. Irvin, who was getting tased, had to sign a medical release. Why did he have to sign a medical release? Because that is really dangerous. And Mr. Bloodworth talked about some of the reasons why you have to sign a medical release. There's dangers from potentially falling. You know that Mr. Irvin had 2 spotters. He weighs, Mr. Bloodworth estimated, about 150 pounds. He had 2 spotters to keep him from falling. Javier didn't have any. And he weighed over 400 pounds.
Ms. Taylor, the state has 20 minutes remaining.
Okay, I'll wrap up quickly. Thank you. Further, they discussed the cardiac risk of tasing and the fall risk that's in the Axon training. The fact that the Axon training, and remember that Axon training that's provided by the company is standardized. That's distributed to law enforcement departments all over the country. They all have the standardized training to administer. They said use the shortest duration of exposure to tasing necessary. Law enforcement are called upon to deal with individuals in crisis frequently who are medically compromised and susceptible to arrest-related death. We're talking about cardiac arrest. So they advise caution in use of the taser. One interesting thing I noted is there was discussion during Mr. Bloodworth's testimony on cross-examination by me that he disagreed with the International Association of Police Chiefs and the Police Executive Research Forum, who say that there's a 15-second maximum, essentially. It's not a hard maximum, but it is a guideline to not avoid that more than that much exposure during one encounter with a subject because it's dangerous. And Mr. Bloodworth said, who is employed by Axon, said that he disagreed with that and he cited some research funded by Axon. Roger Clark, our use of force expert, you may remember, he talked about some of the problems that might help you decide whether or not these actions were reckless, including entering the kill zone, remember the paper and the drawings and stuff, without taking cover, which put Mr. Ambler at risk, and the officer, in addition to the civilian camera crew and the other officers. He talked about a force continuum, distinguishing active resistance and a combative subject with passive resistance, okay? And I think that's really important in this case. And he said even if the body is stiffening, he talked about the fact that multiple tasings can cause a person's body to stiffen up. He said that it is at most passive resistance. The person is not fighting against the officers. He's stiffening up and not complying, which is different. He said that there is no need to tase or forcibly restrain in that situation, that your objectives can be accomplished by giving commands. He also emphasized that officers should wield that power that they have with care and restraint. In addition, Roger Clark noted, when asked under what circumstances it is appropriate to deliver a knee strike, because we definitely see knee strikes in this case on this video. He said, well, it would be assaultive, combative, or significantly resistive conduct. I would suggest to you that although there's some evidence that after attempting to comply, Javier may have been passively resisting when he was stiffening, potentially due to some of the tasing that he was receiving, he was not assaultive or combative or significantly resistive. And Roger Clark said he didn't see anything in these videos that he reviewed that would justify using a knee strike to gain compliance. He also said, and I think this is really critical, and it was echoed by our medical experts, and also our taser trainers. When a person says that they have congestive heart failure, that changes everything, okay? Criminally negligent homicide is one of the lesser included offenses you have to consider in this case. This is basically the same elements as manslaughter, except it's criminal negligence rather than recklessness. There's a different mental state. This is where the person ought to be aware of a substantial and unjustifiable risk that the result will occur. They are in recklessness, they are aware of it. In criminal negligence, they're not aware of it, but they should be. But in both cases, the critical factor is, did they perceive the risk, yes or no? If yes, then you're looking at whether it's reckless and it's manslaughter. If no, then you're looking at whether it's criminally negligent, and it might be criminally negligent homicide. This is if you find that these officers' actions caused the death. In both cases, to reach this beyond a reasonable doubt standard on these offenses, there has to be a gross deviation from the standard of care that an ordinary person would exercise. You also have, as an option here, I'm not going to talk much about it because I want to leave Mr. Guilford time to talk, you have assault with bodily injury. It's a misdemeanor, and that's if you don't find that the actions of these officers caused the death of Javier, but you find that they caused bodily injury. One of the things that we talked about during jury selection is what that means. It's any impairment of, it means physical pain, illness, or any impairment of physical condition. Again, you don't have to be unanimous about the different manner and means. Dr. Pinkert testified about this, neck injuries, hemorrhaging of the strap muscles, said it was consistent with blunt trauma in that area, talked about injuries to Javier's torso, talked about internal hemorrhages to tissue under the skin, talked about a contusion to his right arm and his right wrist, and puncture wounds on his abdomen and left forearm, probably associated with taser bars. Here's a picture illustrating that on the left arm with some blood. Dr. Freeman also testified about this, talks about him being tased multiple times, total of 4 times in 20 seconds. And he talked about the pain compliance tasing and how that also contributed to the injuries and also the death of Javier. He said, significantly, skin is still skin. I mean, a drive stun that is meant to produce pain on the skin. Obese people feel pain just as well as skinny people. There is one justification that you'll find in this case. It's the arrest and search justification. The important thing to remember about it is these are the critical things that the state has to prove beyond a reasonable doubt. A peace officer has to disprove beyond a reasonable doubt. A peace officer is justified in using force when and to the degree the officer reasonably believes the force is immediately necessary to make or assist in making an arrest. I would suggest in this case, and we had the reasonable belief, is that of a ordinary and prudent person in the same circumstances as the actor, not the subjective belief of the actor. I would suggest that the information available to these defendants will help you make the decision that what they did was not justified, that it was unnecessary, that it was unreasonable, and that it was unjustified. Things that you could look at. This was originated with a failure to dim headlights. You have the CAD documents to determine what the defendants' information they had available to them in the chase. You can also listen to Deputy Johnson narrating the chase to determine what information they had to them. There was a disabled veteran license plate involved here. They had the fact that he got out and raised his hands, beginning to attempt to surrender, stated he couldn't breathe, stated he had congestive heart failure, and demonstrated no assaultive or violent behavior towards the officers. I'm going to go ahead and wrap up because I want to make sure Mr. Guilford has some time. Thank you very much for your attention. We really do appreciate it.
Okay, please report. Jury instructions that you just heard twice for both of our clients are obviously dense and they're complicated. Between the attorneys in this room, including the judge, we spent 4 hours yesterday and 3 hours this morning hashing through those. So it's tough for us. It's undoubtedly going to be tough for you. And on that point, we have prepared something to assist you. This is a flow chart. We've noticed some of you have been taking notes. You are free to take notes again at this point. And if any of you think that this may help, I'm going to stand here and I'm going to watch. And if anybody would like to jot that down or copy it, I'm going to let you do that. And I'm not going to rush you. We've got plenty of time. So I'll just stand here until everybody appears to be ready to go. Of particular importance is the first question. This is the important one. Everything hinges on the first one. Did the state prove to you, beyond a reasonable doubt, that the defendant's acts, and we're talking both Mr. Johnson and Mr. Camden, were not a justified use of force by a peace officer making an arrest? In other words, if you believe that the force that they used, considering all the witness testimony that you heard, was not an unreasonable use of force by them in trying to arrest Mr. Ambler, the answer is no. You are done. You are finished. It is a not guilty of all counts. That's it. You don't have to talk about anything else anywhere in the jury charge if you think the force that they used was reasonable under the circumstances. Now, the rest of the flow chart, of course, proceeds in the event that one or more of you think that the force that they used was unreasonable. So, this language here at the bottom, it's from the indictment, and it's also in your jury instructions. And unfortunately, I had to object when the state, in my opinion, attempted to mislead you about that. This is what they're indicted for. The defendant further acted recklessly by continuing all described restraint and actions when Javier Ambler stated on multiple occasions he could not breathe and had a health condition. Now what that does is there in the title, that is now limited the time period that you are to consider. Because the complaint is, and what they're charged with, and the conduct that you're considering, is only after Mr. Ambler said Either I have a health condition or I can't breathe. What that excludes is the first deployment of the taser by Mr. Johnson, the one where the probe shot out. That conduct specifically, they are not charged with. That is not to factor into your deliberations as to whether or not that use of force, that tasing, was reasonable or not. He's not charged with that conduct. Only after Mr. Ambler first said one of these things. As a criminal defense attorney, you could probably assume that a lot of the people that we represent are guilty. And maybe they're guilty of the crime charged, maybe they're guilty of something else, but, you know, they came into my office for a reason. And we take those cases to trial, just like any other. The scariest cases, the ones that keep you up at night, are the ones where your client is innocent. Those are the hard ones. And we know that sometimes innocent people are convicted. And when that happens, it's frequently the case that it's because of what the defense attorney did or didn't do. If a person is innocent, they should not be found guilty, but if they are, we're gonna take responsibility for that. Maybe that's fair, maybe it's not. But that leads into my point, which is the tasing. When you have a situation like this, you have to do everything that you can, including signing up to be tased in front of the jury, and you have to deal with that. And if I hadn't done that, and they're found guilty, and there's something else I could have done, even if it involved 5 seconds of excruciation, how am I going to deal with that? So, you did it. We sat here, I got tased, and you saw it. Now the point of that was to show that's what it looks like when somebody gets tased. You all got a front row view. You saw how my body reacted to the electrical current going through my body. You got to see the seizing. You got to see the muscles contract. You got to see me go up on my toes, my head go back, none of which I felt at the time. But that's the control. So if this is a science experiment, that's the control. I was the control. This is what it looks like when a person gets tased. So the point here is contrast that with what you saw in the videos. For the second, third, and the fourth deployments, did you see Mr. Ambler do any of the things that you saw me do? Obviously the answer is no. None of them. He's fighting the entire time. He's moving. He's rolling around. He's able to talk. And the importance of that is they weren't effective. Despite their attempts, despite the training, they just didn't work. Mr. Ambler did not seize. He did not appear to be in pain. They appear to have no visible effect. The medical examiner testified no marks indicating that any of that was effective. So if we exclude the first tasing, because it's not under consideration, look at the second, third, or fourth, there's literally no evidence that any electrical current went through his body. They're charged for, in part, tasing him during this time period. But you just heard no evidence that it actually worked. The logs, the charts that you saw, they just indicate when a trigger is pulled. Nothing on those documents indicate anything other than that. They don't indicate it was effective. They don't indicate current went through his body. Okay. A little bit more of the law. So I have to do this, unfortunately. Recklessness and criminal negligence. These are called the mental states. And this is what's in somebody's mind, allegedly, and what makes them guilty of certain acts if they committed a crime. So a person acts recklessly, and this is taken from your jury instructions, or is reckless with respect to the result of his conduct when he is aware of or consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. So, the yellow words we got to break down a little bit. First, person is reckless with respect to the results of his conduct. His first yellow words mean the death of Ambler. So, with respect to Ambler's death, there's a connection there. When he is aware of or consciously disregards a substantial and unjustifiable risk that the result will occur. What the state has to prove to you, all of which beyond a reasonable doubt, was that Mr. Johnson and Mr. Camden were aware of but consciously disregarded a substantial and unjustifiable risk that Mr. Ambler would die. So, applying it here, they have to prove to you that they knew there was a substantial and unjustifiable risk that he would die, and they ignored it. Last of the yellow words, that risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. So, gross deviation, meaning way outside of what a reasonable officer would do. Ordinary person, exercised under all the circumstances. This is the important part, as viewed from the actor's standpoint. So you consider what these two individuals' standpoint was. And when you consider that, you can take into account their law enforcement training. So we're not talking about how would just a regular, average Joe Schmo off the street think of this. No, it's these two. And you can take into consideration that they're police officers. So, as viewed from their standpoint with their training, as an ordinary police officer, if they grossly deviate from any of their training, from any of their policies, from the law, from anything that any other police officer would do under the same circumstances. Now, for criminal negligence, so it's criminally negligent homicide, the only difference here is this part, be aware of. So for manslaughter, it's the original indictment, they have to be aware of the risk that he would die and ignore it. For criminally negligent homicide, it's one step below. I don't have it up here, I'll just tell you. It means they didn't know, but they should have known. In other words, they didn't know that wrestling Ambler and getting him into handcuffs would kill him, but they should have known that. So that's the one step lower for the next lower crime. And then assault, that removes the causation part. So for assault, we're not talking about Ambler's death at all. We're just talking about when these police officers followed their training and they wrestled Mr. Ambler and they grabbed him and they tased him, tried to tase him, the second, third, or fourth time. Were those actions alone assault? No, obviously they're not assault. Police officers get to do that within the bounds of the law. And what's reasonable or not comes from training, experience, prevalent standards. Now, the difference that if we go back to the flow chart, which we'll just do. For any of the three offenses, manslaughter, criminally negligent homicide, assault, it's still the same analysis. If you think that their efforts in taking him into custody and trying to get him into handcuffs, if that was reasonable, you don't make it past. It's not guilty for manslaughter, it's not guilty for criminally negligent homicide, it's not guilty for assault. All right, so let's talk about this aware of but consciously disregards the substantial and unjustifiable risk that the result will occur. Here the evidence is, well, but Mr. Ambler said, I have a heart condition. I have congestive heart failure. I can't breathe. So that's the evidence that the state is giving to you to show they knew he would die. They knew there was an unjustifiable risk that he would die if they proceeded to get him into handcuffs. Now, Dr. Freeman, the state's expert, right, I made a little show about this. I asked from there, can you tell whether I have congestive heart failure? No. Came up and stood here. How about now? No. Came up to him. All right, I'm closer to you. Can you tell whether I have congestive heart failure? No. I turned around, changed it again. I said, what if I tell you I have congestive heart failure? Can you tell? No, you can't tell. State wants you to think that these officers were aware that Ambler had congestive heart failure. They're literally alleging that they were qualified to diagnose him with this and knew that he had it and knew that if they continued, he was going to die. State's own expert can't do that. And of course, it's absurd, right? You can't tell that. That's why you go to the hospital. You have tests. You have electrical tests. You have blood tests. This is how we know whether a person has congestive heart failure. It's not just because they say it. No reason to think that. State's own trained medical professional couldn't do it either. Now, there were some things I think that the deputies, they could reasonably infer from the situation, and one's, the size. He's a big guy. He's 410 pounds. And I believe the testimony was we needed 3 handcuffs to get behind him. And nobody had ever seen that before. I think the officers may have said, he looked like he was going to need 2, but in fact, he needed 3. Now, the point here is, this is what they could see. This is what they had experience with. They knew he was big, thought it was going to take 2, but they didn't know it was going to take 3. And they didn't know that until they actually tried. And only at that point did they realize this is not going to work, and we need 3. Point being, they could tell something by looking at him, that he was going to take some extra cuffs. They got that wrong, it took more. But they can't tell that he has congestive heart failure. They can't tell that he's dying. Now, obviously, Mr. Ambler was resisting arrest. And just like we said in opening, we suspected every police officer took the stand pulled by either side was going to say he was resisting. And they were also going to say the use of force was reasonable. In an opening, I offered, we're probably just going to hear one person say Ambler wasn't resisting, and that's going to be one of the state's paid experts. And that was true. My prediction was true. Mr. Johnson said he was resisting in the video. Mr. Camden said he was resisting in the video. Austin Police Department Detective Aaron Truehope said he was resisting. Austin Police Department Sergeant Rob Gilbert said Ambler was resisting. APD Detective Billy Parks said he was resisting. Williamson County Sheriff's Office Assistant Chief Jay David said he was resisting. APD Officer Michael Nissen, resisting. Former Travis County Sheriff's Office Commander Mark Sawa, our expert witness, said Ambler was resisting. But it's not just law enforcement. You heard from 3 live PD employees, former, Mr. Tarzian, Mr. Moriarty, and Mr. Miko. All of them said he was resisting as well. And then, on top of that, it was the state's use of force expert, of course, who said, I don't know, he's not resisting. But strangely, Mr. Freeman, the doctor, the medical expert, called by the state, paid to come here, he agreed with me. And he said, yes, Ambler was clearly resisting. He wasn't supposed to say that. And on redirect, here, hopefully you caught this. There was a number of questions Well, sir, police officers use terms of art. And it's active resistance and passive resistance, and you didn't mean that, did you? Hey, you didn't mean that, did you? And of course, he got the hint, changed his answer, and then finally gave her what she wanted, because he was not supposed to say that. But he didn't get the money. Worse than that, I think, was the probes. When I asked them to confirm how many taser probes were in Mr. Ambler's body, he said 4. I gave him, I think, a couple of opportunities to correct that. He didn't. He doubled down. He said that was 4. Oops. That was an awkward moment for me, given that probably everybody in this entire courtroom, except for him, knew that it was 2. This is the state's paid expert. This is what they brought you. This is the level of preparation, level of professionalism. I think it's really reflective of the entire case, but I've never seen someone get something wrong that was that important. Top of that, person you didn't hear from, the expert use of force witness was not called by the state. Mr. Joyner also told the DA's office Ambler was definitely resisting. No surprise he was not called by the state. Only person to say not resisting was Mr. Clark. He was last police officer in 1993, over 30 years ago, and paid to come here from California. Now, let's talk about the recklessness. The allegation is our clients acted reckless in continuing to use force after Mr. Ambler first said, I have a heart condition or I can't breathe. So, okay, let's do the same thing again. Who said the use of force was reckless? Again, almost everybody. Deputy Rachel Lentz, APD Aaron Truho, Rob Gilbert, Billy Parks, Assistant Chief J. David, Michael Nissen, Commander Sala, now Williamson County Sheriff's Office Deputy Anthony Ramirez, also said the use of force was reasonable under the circumstances. Again, non-law enforcement said the same thing. When asked if anything that our clients did at the scene appeared to you unreasonable, the 3 non-police officers also said no. And they testified how long that they have done this, how many cases and ride-alongs and filmings they've done with police officers, and it was shockingly a lot. So they do have a background. Like they have a basis of comparison here. And they all agreed same thing. Nothing looked unreasonable about wrestling him, about trying to tase him 3 times in order to get handcuffs on. Again, it's only the state's expert, paid to come here from California, who said, no, unreasonable, shouldn't have done any of that. Now, what was interesting about Mr. Clark, I thought, was he never said what they should have done. So he just said, well, not that. But he didn't say, this was the proper procedure. This is current training. This is how it should have been handled. He didn't offer it. And I don't think that that was a mistake. I think that he wasn't asked that because there's not an answer. And he knows there's not an answer, and he can't give one. So they just skipped right over that, and we had to clean it up. My co-counsel, Mr. O'Connell, had to do their job for them, try to fix that, and go through the options. And that was, well, what should they have done? Now, we did this with Mr. Sawa, not with Mr. Clark, but its options are do nothing, right? Run away, shoot him, hit him with batons. Okay, if this was wrong, then what was right? And there's no answer to that because none of those are right answers. The right answer is they should have done exactly what you did. And again, I'm going to stop going through the list, but every witness who was asked this question confirmed when somebody is about to go to jail, and they know it, they will say anything to get out of it. Anything. And in particular, something's wrong with me medically. I need an ambulance. I can't breathe. I've got a bad back. Anything at all, just because they know they're going to jail and they don't want to go to jail. And so it's not a long-term solution. The people who say these things, they say, I need an ambulance. They're just thinking 1 second ahead. If I say this, maybe I won't go to jail right now. Maybe I'll go to the hospital first. Maybe this is how I get out of this. Maybe I'll go to the hospital and they'll forget about it, and I won't go to jail. So to the extent that Mr. Ambler is saying, I can't breathe, or I have this condition, this is consistent with the lies people tell that you have heard from witnesses on the stand that happen all the time. You also heard once the cuffs go on, don't need an ambulance anymore, right? And so that's how we know these people are lying. What we did see was what was supposed to happen. Handcuffs in this situation go on now. If there is a medical situation, we will deal with it. The video shows Mr. Johnson actually called for an ambulance while he was still struggling with Ambler. Right? Not at the end, not after he was found passed out, but before. That's on the video, you can hear it. Once Mr. Ambler became unresponsive, he was sat up. Here come the sternum ropes. Immediate medical care. Exactly what they were supposed to do. Exactly consistent with training. These individuals had no reason to know that Mr. Ambler did in fact have such a serious health condition. And even if they knew, and even if he did, he still did the right thing, because he ran for 20 minutes. He kept crashing his car. He was ignoring commands. Even if these things are true, they did the right thing. They did it as they're trained, and they did what other officers would do too. Get him into handcuffs, make him safe, so he can't hurt us, he can't hurt himself, he can't hurt a third person, he can't run, and then we will get him medical care. That's exactly what happened. This is not reckless. This is training. Now, somebody did know about the heart condition. Somebody did know about the risk. And obviously we know who that was, and it was Mr. Ambler. Mr. Ambler knew he had visited the ER 18 times for shortness of breath in the months preceding his death, at an average of about once a month. He knew he was short of breath. He knew it was constant. He knew he would get short of breath from putting his socks on. He knew he would get short of breath from just sitting there. He also knew what happened when he would run out of heart meds. And toward the end, the last several visits, that was the pattern. The pattern is, I am now back in the hospital because I had shortness of breath. My symptoms have skyrocketed, and it's because I'm out of meds. Immediate. The day after he would run out of meds, 2 days, 3 days, he would come back because the symptoms were unbearable. He also knew what would happen when he ran out of meds. He also knew he was told not to do that. He also knew you could die. It's an enormous risk if you run out of meds. So plan ahead. Don't kill yourself. Don't put yourself in this situation, and get your meds before you run out. And again, and again, and again, he did it. That's reckless. Mr. Ambler knew he could die. He was aware of the risk. He consciously disregarded a substantial and unjustifiable risk that he could die from this. He did that. The state proved recklessness, but it's Ambler's recklessness. And this is not fun. It's not fun to pile on Mr. Ambler, but he knew better. And these men are on trial. They've been waiting 5 years for this. Mr. Ambler knew. And do I feel sorry for him as a human being? Yes. But do I also have to point this out? Yes. You heard in the video from Mr. Johnson the direct commands. Get on the ground! Get on the fucking ground! Then the wrestling starts, and you hear the shift. You hear the tone change. You hear, I need you to comply. I need you to comply. It's a pleading. It's an emotional, please don't do this. It's trying to talk to him as a human being and not yell at him as a police officer. It's almost begging. He's telling him, I need you to comply. I need you to comply. He doesn't want to do any of this. But Mr. Ambler is making him. And Mr. Johnson is trying everything possible to try to get him to comply to end this, including going to talk to him in a different tone, using different words, essentially begging him to stop. What did Ambler do? He didn't stop. Obviously, I'll tell you, I'm not a doctor. But I think Ambler's medical episode started well before he crashed out. You see in the pursuit, he's running red lights, also reckless. Driving at a high rate of speed, also reckless. Doing all this with a heart condition, also reckless. Throwing things out of his car, probably reckless in the circumstances. And I think that was probably already too much for him. And his death process, as we have heard, probably started during the chase. Then he starts wrecking. And he wrecks again. And he wrecks again. At first, he's able to maintain control of the vehicle, but that diminishes as it continues, and the collisions get worse. And if you are having a medical episode, you are not getting enough oxygen to your brain and to your organs. You start to lose motor function, right? You're starting to pass out. You're starting to go into a very serious state, and you start to lose control of a car that you were trying to drive at a very high rate of speed. Crashes, the door opens, and regardless of what Mr. Ambler intended when he got out of the car, you can see it's difficult for him. You can see he's struggling when the door opens, right? So the door could have flung open, he could have jumped out on both feet and bolted, but that's not what he did. He's sort of stumbling, he's got one hand maybe up, one hand in, he's not steady on his feet. This is the medical episode and the progression of it, and he's at the point where he's having difficulty getting out of the car on his own. He said he couldn't breathe, by my estimation, only a few seconds after Mr. Johnson first touched him. That short time duration tells you this was a problem long before Mr. Johnson first told him. Before he told Mr. Johnson he couldn't breathe. Because if that's not the case, and what the state wants you to believe is that everything is fine, he's living, he's walking and talking, there's no issue here, right? Perfectly healthy. But then, boom, once the hands go on, heart attack, and now he has a medical condition. Well, to make sense of that, we're talking about a few seconds from Mr. Johnson touching him to him saying, I can't breathe. And that doesn't make sense. It wasn't the hands that made him say that. He said it because it was already happening. Mr. Ambler was in the exclusive control when he got medical care. If he was having a problem in the first mile of the chase, he was in control. He could have pulled over and have, at least some medical training right there available, and an ambulance as quickly as possible. He wouldn't even have to call it. Second mile, third mile, 10th mile, 15th mile, 20th mile. At any point, he could have just pulled over and he could have got medical care. Is he going to go to jail? Absolutely. Is he going to die? Maybe not. He didn't. That's reckless. Mr. Ambler was reckless. Even if we go to the point of the final collision, when he gets out, Mr. Ambler still delayed his own medical care for another 2 minutes. He just needed to comply. He just needed to stop. Put your hands behind your back, and you're going to get an ambulance. Like he said, I need you to comply. I need you to comply. Still nothing. Still didn't do it. And this office wants you to think they killed him, that that's their fault, not Mr. Ambler's. I don't know where personal accountability went in any of this, but they're doing their job. Mr. Ambler committed multiple crimes, felonies. He did this to himself.
When I'm trying to handcuff somebody, that's not the time that I am going to have a conversation about whether or not these handcuffs are going on.
All right, this is just one example of an officer saying, this is not how it works. I'm not going to stop just because you tell me you're having a medical condition. Now, Mr. Pinkard, it's the first time I've seen the DA's office call an independent paid ME and medical professional and fly him in from another state and not call our own independent Travis County medical examiner. Now they did call him second, but they didn't call him first, and they didn't just use him. This is why. The very specific questions that I asked them on the slide, including, right, Mr. Pinkard, the Travis County medical examiner, Mr. Ambler's pre-existing medical conditions, 22-minute effort to evade arrest, 3 collisions, and physical exertion in struggling with the deputies. Prior to the time, Mr. Ambler first said, I can't breathe. Could all of that have been sufficient to cause Mr. Ambler's death? He says yes. And he wrote it right there in pen, just like he did with the next 4 slides. Now with the next 4 slides, I kept removing factors. Okay, medical conditions, 22-minute chase, 3 collisions. Yes, sufficient to cause his death. Mr. Ambler's pre-existing medical conditions and 22-minute effort to evade arrest, sufficient to cause his death? Yes. Mr. Ambler's pre-existing medical conditions alone, sufficient to cause his death? Yes. This is where this ties in. Mr. Camden and Mr. Johnson are criminally responsible for Ambler's death if he would not have died, but for their efforts to arrest him, either operating alone or concurrently with another cause, namely Ambler's congestive heart failure, unless the concurrent cause was clearly sufficient to produce the result. In other words, was Mr. Ambler's concurrent cause chase, collisions, congestive heart failure, resisting arrest, were those clearly sufficient to produce the result, meaning cause his death? Yes, 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 yes. That's why they didn't call him first. Because the state loses on that alone. Dr. Pinkard testified all that was sufficient to kill him. Okay, that's part 1. Part 2, and conduct of the actor clearly insufficient. So in other words, were their efforts in restraining him clearly insufficient to cause his death. So let's go over the evidence that you heard about that. That's it. None. You didn't hear any. It is the state's burden to prove beyond a reasonable doubt that trying to tase Mr. Ambler 3 times and wrestling with him to get him into custody, that alone, 3 tasings, wrestling match, was that clearly insufficient to cause his death? Nope. There is no evidence. That's on the state. It's a failure. That's another acquittal. What's the second now reason? To the extent that Dr. Freeman testified differently, the paid expert from Oregon versus the actual one who supervised and signed off on the autopsy, the person not paid to be here, Dr. Pinkard, to the extent that there is a conflict between those two, I would certainly suggest the independent medical professional, out of vested interest in saying what they want him to say, that's who you should believe. Not the paid expert who said there were 4 probes in the Ambler's body.
Because of the struggle and restraining procedures that were happening, all of the events that were occurring immediately surrounding his death, that those actions were simply too much for his heart to take.
Right. Correct. It was too much for his heart to take. And who knew that was going to be too much for his heart to take? Right? Ambler. Who didn't know? Who had no reason to think that? Mr. Johnson, Mr. Camden. Now what he's saying in medical terms is, because there was a 2-minute wrestling match before his death, that undoubtedly exacerbated and sped up Mr. Ambler's death. However, he was not able to say that Mr. Ambler would have lived if they stopped. So, slide 5 and slide 6 for Dr. Pinkard. Given Mr. Ambler's pre-existing medical conditions, 22-minute effort to evade arrest, 3 collisions, and 2 minutes of physical exertion and struggling with officers, can you testify to a reasonable degree of medical certainty? In other words, yellow language, right? This is the legal language, but I got to talk to him in his medical language, which means to a reasonable degree of medical certainty. Can you testify to a reasonable degree of medical certainty that Mr. Ambler would have lived had Mr. Camden and Mr. Johnson stopped their efforts to restrain Mr. Ambler after Mr. Ambler first said, "I can't breathe"? Can you say he would have lived if they immediately stopped? No. In his handwriting, no, I cannot say that. Lies back to the first 4 questions, meaning, no, I can't say that because all the other things were plenty to cause his death alone. And number 6, really the same question, just phrased now, using the state's words, but for. Can you say, Dr. Pinkard, to a reasonable degree of medical certainty that Mr. Ambler would have lived but for Mr. Camden and Mr. Johnson's continued efforts to restrain Mr. Ambler after Mr. Ambler first said, "I can't breathe"? No. No, he can't. He's the independent medical professional. What he's saying is, no, I absolutely cannot say that Mr. Ambler would have lived if they would have stopped, because all of that was sufficient to cause his death, even if they stopped. Okay? So, that's this. That's concurrent cause. Congestive heart failure. All of the other things Ambler did. Yeah, clearly sufficient to kill him. And the conduct of the actor, clearly insufficient. He can't say if they would have stopped, Mr. Ambler would have lived. This is another failure of proof, and I mean fatal failure of proof. That this is a not guilty. There's no way around this. All right. I don't want to do this, but I have to. The Texas Disciplinary Rules of Professional Conduct, rules lawyers have to abide by, state number 3.09, special responsibilities of a prosecutor. The prosecutor in the criminal case shall, must, have to make timely disclosure to the defense.
Excuse me, Judge, pardon me. Isn't the law supposed to come from the court?
It's just argument, I'll allow it.
I understand why I don't want you to hear this. Make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. Live PD footage. Failed to obtain it. Failed to disclose it to us. Ambler had an active warrant at the time of his arrest. They failed to obtain that warrant, and they failed to tell us about it. Failed to give us the visually enhanced video made by Williamson County evidence tech Ron Baldwin. Mr. Ambler had 3 cell phones in his car. That's consistent with the things being thrown out the window. They failed to give that to us. Mr. Baldwin came prepared literally with receipts. He had emails. He was ready to go because he offered, I can give you a visually enhanced video. Do you want that? I'll get back to you. Never did. A minimum, the state's on notice that he can do this. They didn't want it. Why? Because it would hurt them. 3 cell phones. Who knows what's on that phone? Maybe nothing. Maybe nothing that helps you decide this case, but maybe there was. Didn't do that. Didn't pull the data off, didn't see who he was calling, what he was texting, what was in there. Didn't do that. Why? Perhaps most importantly, the Fitbit. Right? If you have one, if you're familiar with it, you know they can track heart rate. That could have been downloaded. That could have tended to negate the guilt of Mr. Johnson and Mr. Camden. We raised that last week. Still don't have it. From the point that we raised that until the point that I'm standing here right now, we still don't have that. We still don't know what that Fitbit says. Why is that? I don't have that. Why didn't they give it to us? Well, probably the same reason that this DA's office consulted with the use of force expert, who didn't tell them what they wanted to hear, so they didn't call him. Mr. Joyner. Ms. Taylor, in her opening statement, going to try to soften that blow. She knew it was coming. In her words, right? Right now I'm paraphrasing, but it's, you will hear that we consulted with the use of force expert who told us their use of force was legal and justified. Now I'm quoting, and we struggled. Struggled with what? What do you mean struggled? This guy that you trusted, that you consulted with, that you would have hired if he agreed with you, told you were wrong. What do you mean you struggled? There's only so much that I can argue under the rules here, so I'm just going to hold this up. I'm going to remind you what yesterday was and what yesterday was 4 years ago on the same day. Sorry, day before last Tuesday. There's a timeline in here. It's assigned to this DA's office under a certain administration. 16 months pass. A certain important day is in the middle here. And then shortly after, indictment. I'm hoping you can understand the point that I'm making here. That's probably not as much as I can say. Struggled with what? I would suggest struggled with being forced to continue to prosecute this case after you are getting evidence from experts saying this was not illegal. I'll struggle too. And here we are. Struggled with what? Struggled with trying to come up with a reason why only the Williamson County guys are indicted for a crime, but not the Travis County guy. That's a struggle too, yep. Officer Newsom, while didn't deploy the taser, he did also go hands-on, and he did a lot of the things in the indictment. The state alleges these former Williamson County deputies were guilty of, but they only indicted the Williamson County guys. Yeah, I would struggle with that too. I would struggle to justify and try to explain myself to a jury if I had to prosecute that case. It would be an enormous struggle to justify why that is. Enormous struggle to come up with a legitimate, proper, ethical reason. We don't think that you'll struggle. We think this is honestly fairly straightforward. We don't think it's a struggle. We think that we probably didn't need to ask much. I think the state alone, through their questioning, established that what they did was perfectly reasonable, was lawful, well within the bounds of the law. That's why we took just a very short time when it was our turn, because there just wasn't much more to prove, to show you that there was no crime committed. And it shouldn't be a struggle. We deliberate to sign on the very first blank that says, "We, the jury, unanimously find the defendant not guilty of all charges." There won't be a struggle for you to sign 2 copies of this, one from Mr. Johnson and one from Mr. Camden.
going to be speaking faster than I normally speak. I have a very, very short amount of time to cover a number of things with you. I'm going to tell you this real quick. Due northeast, about 8 to 9 miles, is a little community called St. John's. It has been there since the 1890s. It is like many inner city communities. It's had its challenges and it has survived. Mr. Ambler died in that community called St. John's on a street called Bethune. I don't have a lot of time to tell you who Miss Bethune was, but she dedicated her entire life to aligning herself on the side of truth and justice and acting on it. You all are going to have to do that in this case. I can't be more direct with you because I just don't have the time. What I mean is, if you acquit these defendants, you will necessarily have to adopt a version of how Mr. Ambler died that is simply untrue. It's simply untrue. I really want you all to appreciate what you're being asked to do here. You all are being asked to stamp with all of the force and effect that comes with a jury's verdict a version of facts about how that man died on Bethune Street at the hands of these two defendants. And it is noteworthy that they stayed away from it as best that they could. The simple fact that Javier Ambler died a surrendering man, a complying man, and a begging man, and that they had all of the power and authority to do something different and did not. How do you know he has congestive heart failure? I don't expect you to know that, but he told you. Here's the truth. Here's the truth about how he died. He got out of his car, indicating that he was surrendering. You saw his left hand up. We don't know where his right hand was, but it was up. We know that there was nothing in the vehicle that he could have been reaching for. He was tased. He gets on the ground. He falls to the ground. And the first command given to him after he's fallen on the ground is to roll over, go watch the tape, watch the video as many times as you want, because you got to get this right. You're being asked to do something that's going to sully the dignity of this court and the soul of this county. And I'll come to the last thing I'm going to talk to you about is that part. The first command after he goes to the ground, first let's back up, was no reason to tase that man. How do we know that? What's the standard in Texas? It's immediately necessary. It's the law. You'll see it. Immediately necessary. Pull up my PowerPoint, please. The law allows you to define what immediately necessary means. How do we know that there was no exigency that required him to be tased? Because as you heard, even their expert, Mr. Sawa, told you that the biggest component in any situation where an officer is facing possible risk of injury, the need to use force, is how to manage time. That's the one thing you can't control. Why? Because you got another subject here who you do not know what he or she is armed with, what their intent is, what their state of mind is. The only thing you have are tactics that allow you to, as best you can, manage time. Cover, concealment, distance. You all remember that. They drill these officers in that. And what did this officer do? Defendant Johnson? Concealment wasn't an issue, but he abandoned cover, closed the distance. That's how we know that there was no exigency. Mr. Ambler simply didn't move quickly enough for him. So he tased him. And he took that situation, which now is one that he has to go hands-on, and the first command he gives is the rollover. And you got a 410 plus pound man. Go watch the video and see what he does. He rolls over. Resisting? In what world is that not? The first, I mean, it's so basic that it feels so basic that I'm sorry we even have to do it. Let's first arrive on what a definition of compliance is. Let me suggest one. I give a command that's clear, which the other person can comply with, and I give them an opportunity to comply with it. Roll over. Remember, he tumbles to his back and he rolls over. It's called compliance. I don't care what world you're in. That's compliance. Next command. Give me your hands. What do you see this man do? 410 pound plus man offers them his hand and holds it back for 4 seconds. Offers them his arm and holds it back there for 4 seconds. And this man, this defendant right here, pushes it down to the ground. Resisting? Not complying? Fighting? You have to adopt a false, fantastic falsehood to acquit these men on those grounds. That's not what happened. I want you all to understand what's going on here. Third thing, after they frustrate his attempts to comply, they ask for his other hand and he gives it to them. If that's not compliance, there is no such thing. If that's not compliance, then what they were engaged in is something else that amounts that approaches punishment, torture. There's no way you all can look at that video and conclude that Javier Ambler died a non-compliant, resisting, fighting man. It ain't true. The man's father sitting right there. He learned the details about how his son died when you did. And I'm sorry, I'm upset. But this is incredible. And why is it so incredible? Because people take this chair, colleagues of mine, and I can ask them the question. Show them the video. Do you see him offer his arm in response to a directive to give it to them? No. Let's watch it again. Do you see it? No. Well, what about, do you see him push his arm back down the ground? No. Well, what about the other arm? I didn't see that. You got one question. Oh, let me back up. This same witness, you might remember, described in detail the way the dust kicked up on one of the collisions as he's going through the intersection. Detailed. I said something to him about it. And he doesn't even, first of all, he didn't remember it. And then he didn't see it when, there's a reason why he doesn't want to see it. It gives truth to the lie that Mr. Ambler died, a fighting, resisting, non-compliant man. That's not true. And you all know that's not true. So let me tell you what's going on here. That's a narrative, will allow you to walk back to your lives, tell yourself and your friends that that's what happened if you decide to quit, but it ain't true. Don't change what happened on Bethune Avenue, named after a little woman who dedicated her life to finding herself on the right side of truth and seeking justice. Y'all need to seek justice, and it ain't with this fantastic story that is belied by the evidence that you're going to have with you. This is a playbook. If these defendants did not know anything about, y'all remember the demonstration with all of the things being thrown out of the car? Why are we talking about that? Javier Ambler deserved to be arrested, taken to jail and booked, given a place to, given a place to spend the night, and if he couldn't make bond, end up in the courtroom just like this, and one of our officers, prosecutors, prosecute his case. That's what he deserved. And it was their job to make sure that that happened. That didn't happen. Although he was a compliant man. He died a compliant, non-resisting man, pleading for his life and supplying them with all of the information that any decent person would have found a way to, at a minimum, stop tasing him. Matter to you all? Are you all moved by the fact that somebody from California is the one that came and told you that? Oh. Look, you all got a decision to make here. They rattled off all, but they could have we could have called 20 police officers in these cases and they would have probably said the same thing. And you know how many times Javier Ambler would have been dead had they been the responding officers? 20 times. What you all need to know is, all that showed you was that if we leave it to them to come up with something different that truly reveres the sanctity of life while ensuring that they protect themselves and the rest of us, it's not going to happen. This video is now part of the public record. What happened on Bethune Street happened, and nothing you all can do can change it. Your verdict can, however, vouchsafe the truth in what happened. If you acquit, your verdict can ignore and deny what happened, but it's not going to be the truth. Listen, in the latter part of the last few minutes of Javier Ambler's life, you will see that he braced himself. Now let's assume for a moment that that's non-compliance. So the latter part, this is after he's offered them his arm, both arms. This is after he's rolled over and the man is dying. And he's begging them to do something. After he's finally convinced they're not going to do a thing, the last thing this man does was try to keep himself propped up so he can breathe. That's your resistance? After the people who had custody, there were 5 officers out there on the scene. 3 of them hands-on. Go look at your video. You'll see Mr. Ambler in one of 3 poses the entire time. This. I'm sorry I'm not trying to be in your personal space, but that happens to be where this table is. Those are the poses that that man assumed for the entirety of the time before he died. And all of them were his attempts to make sure that he could breathe when they would do nothing to alleviate what he was telling them. Look, you all heard the playbook. DA's office hides evidence. Javier Ambler's had 3 cell phones. He possibly was going to meet up with his cohorts. Tell me what any of that has. How does any of that help you decide whether he was resisting them and that there was an immediate need to use any force against him? It does not. trust me, I've seen this. It's to help you become more comfortable with this false narrative that they're telling you as to what happened when you got the video in front of you. Don't let that happen. There's too much being sacrificed here. We always talk about the sacrifice that our police officers and our armed services members make, which his father's one of them. They sacrifice their lives and put it on the line every day. But do you know what the biggest sacrifice is? The one from which there's no return? It's when you sacrifice the ideals that people like his father make. The ideal here is truth. Y'all know what happened out there. You got the video of it. This ain't for, Kim wants to go across the state bar and complain on me on this case, he's welcome to it. I don't, that's his business. I'll deal with that. But don't y'all walk out of here. Don't walk out of here basing your decision on, at a minimum, that first thing in his decision-making model, that would solve 3 of them right there. None of this was immediately necessary. And you could deal with the causation, but none of this was immediately necessary. That little neighborhood where he died, it's called, it's designated as early type 1. That's what policy planners and urban planners use to designate areas that are gentrifying and transforming at a rate that there's a threat to the sort of fabric of that community. It's a type 1 neighborhood. Why am I saying that to you? In 3 years, that place where Mr. Ambler begged for his life and spent the last maybe minute trying to save it by doing nothing more than propping himself up off the ground. 3-4 years from now, those will be condos. Those will be condos. And this will be nothing but those of us who saw the case, something that experienced in our lives. People who lived there will probably have been, some of them in high school when this happened. And the city moves on. I want to tell y'all something. When we talk about infrastructure of the place, and we all live here, we all have, some of us have children here, our loved ones are here, we work here. When we talk about the infrastructure of these communities, oh, it's not just whether or not you got transportation, healthcare access. It's not just those things, quality of schools. There's another infrastructure here that got to do with the soul of this place. And right now, y'all are his caretakers. Y'all aren't his caretakers. Y'all know that man died out there begging and pleading for his life, and all this nonsense that Mr. Irvin's talking about just ain't true. And I've told you the truth by saying to you, if there was any non-compliance, and I would concede that that is, not allowing them to take your hands after you've tried to comply. It's that man trying to save his life when the public servants who were charged with responsibility, remember Mr. Sawa asked him what's the primary overriding ethical duty of all law enforcement. He said the protection of the sanctity of life. So it's no badge of honor that the police officers who we had to call to the stand are willing to say they do it too. I think that tells you that you're going to have to do something if you think there's something that needs to be done here. Our military answers to our president, who's the commander-in-chief. And in this case, these officers answer to you all. Now, the law does not allow me to tell you all what people expect. It's not the way it works. Permissible closing argument assumes that you all are the ones who send messages out. Your verdict is going to be a message. I'll be here. The Amblers will be here. And everybody that knows what happened, your verdict can either correspond to the truth or you got a choice to make. I'm wrapping up, John.
Okay.
Thank you. You all might remember that I said to you during jury selection, I mentioned to you that, or I may have asked you, I'm not sure, but I mentioned to you all, man, we got a special relationship to the rules that we make, that we live by. I mean, you might fashion a rule in your own home to govern yourself and your family. You all might decide on it. And the idea is that you all are going to submit to this rule for the greater purposes of whatever, how you want to arrange your household or your life. But you have to remember something. These rules are made for you. They're made rules and laws are made for us. We're not made for the rules and the law. Some of you all know what I'm talking about. Right? And so for everybody to come in and say they were just following the rule, your medical distress, the rule is we cuff you first. Well, if that's the rule, something's wrong with that rule because this man is dead because of it. Everybody can consider the totality of the circumstances until it means considering the fact that, in fact, this man, Javier Ambler, was in medical distress. There's no way around the fact that when he stepped out of his car, he was in no medical distress. He was oriented as to his circumstance. He was ambulatory. He was coherent. And that after Defendant Johnson's final tase, within 30 seconds, he's limp. No way around that. Work your way through the I don't have time to go through all the causation, but you all have seen it. But you answer that first question in Mr. Irvin's diagram, that'll deal with 3 of the legal issues. None of this was immediately necessary. None of it was justified. It was unnecessary, unlawful, and unreasonable. Then work your way through the rest of them. Listen, thank you all, especially for allowing me to invade your personal space and so on. But thank you all for your duty. We'll be here. We trust that you all will be filtered to the truth as you can see it on the videos in these cases. Godspeed to you.
All right, ladies and gentlemen of the jury, you may have noticed that there in our very small jury room that there are not 12 of you, there are 14 of you. 2 of you are alternates and will not be joining everybody else for deliberations. I don't know if you remember your numbers, so I'm going to try with numbers and then I'm going to use your first name because I'm trying to keep your identity confidential. But does number 63, do you remember? That was your number? Amanda? Okay. You were an alternate? And Scott? You were an alternate. Okay? So you will, what I'll need from you is just make sure that Craig has your cell phone numbers and contact info. We have places you can wait here, not with the jury if you want, but or as long as we can contact you. The 2 things I need you is that your duty won't expire until this jury reaches a verdict. So until you hear from Craig, you've got to maintain no media, don't talk about the case with anybody else, all of the rules that you've been adhering to up until now, okay? All right, then for the rest of you, here are the court's charge. Him is the bailiff. for you to go back